My name is Tom Roth. I'm an economic and financial advisor and president of the consulting firm, the Labor Bureau Incorporated. The Labor Bureau has been in continuous operation for 90 years and is the oldest consulting firm in the U.S. devoted to providing collective bargaining support to labor organizations, principally in the transportation sector. I have extensive experience in airline labor cost restructuring cases, both in bankruptcy and out of bankruptcy, including all the major cases on United, U.S. Airways, TWA, and Northwest Airlines. It is because of this experience that the TWU had brought me into the American bankruptcy case to develop costing models and perform the necessary economic analysis and provide general advice to your negotiating committees and otherwise help the TWU leadership navigate through the 1113C process. I'm speaking to you today because I've been intimately involved with your negotiating team throughout the 1113C process and have been asked to share my thoughts on the pending ratification vote for both the M&R Group and the Stores Group. Now, I understand that no one can tell you how to vote. It is a highly personal decision, but it's imperative that you decide on all the best information available and not act upon some of the misinformation that is presently circulated about the property. The vote on a tentative agreement does not involve a simple choice between an acceptable and an unacceptable contract. It's far too simple. And that's a choice that's usually reserved for traditional negotiations. In traditional bargaining, the parties understand that their relationship is governed by a continuous duty to bargain in good faith, during which time the status quo principle applies indefinitely. In traditional negotiations, there's a balance of power. The union can create leverage with the strike authority and/or presenting its case before a neutral board, either a presidential emergency board or an arbitration panel. In traditional negotiations, the parties inevitably reach a collective bargaining agreement, even if after the Railway Labor Act procedures are applied and exhausted. The 1113 process is not collective bargaining. The duty to bargain and the bar on the imposition of terms, that is the status quo requirement, are temporary, lasting only until the debtor complies with the minimum requirements of Section 1113C and moves for the rejection of the collective bargaining agreement. There is no true balance of power, no true balance of interests under the 1113C process. 1113 process is best described as meet and confer with the union, but with no obligation to ultimately reach a mutually satisfactory agreement. We made a good case in court in opposition to the company's motion to reject our collective bargaining agreement. Yet I'm pessimistic about our chances of success given labor's record in similar 1113 cases. So the question for you is, what happens next if the TA fails ratification and the judge grants the debtor's motion to reject the TWU's agreement? Under this scenario, the company is free to impose terms and conditions of work. There are no requirements to negotiate during the pendency of bankruptcy, which will last at least through 2012. After exit, the Railway Labor Act takes hold and traditional Section 6 negotiations will commence. But this scenario creates several problems. First of all, there is the risk of imposition. We don't know for certain which set of terms will be imposed by the company. But based by the company's representations, it's likely to be, at best, the March 22nd proposal. It means that the loss of wage increases, the loss of equity claim, the loss of the midterm market adjustment, the loss of early out incentives, the loss of the enhanced 401k, the 24-month early reopener, improved health insurance, the 10-year recall rights, and the return of the company's pre-funding of medical health insurance. And at the minimum, there'll be a massive job reduction. Some 4,600 positions will be eliminated. And make no mistake about it, they will not be retrievable in Section 6 negotiations. What's worse is that without a ratified and signed contract, there are no terms enforceable against the company. Whatever terms that are imposed, they can subsequently be unilaterally changed or ignored altogether until a new collective bargaining agreement is reached. A second problem with this scenario is the duration of Section 6 bargaining itself. There will be no duty to bargain during the pendency of bankruptcy. The negotiations will likely be placed in what the NMB refers to as the deep freeze. This will obtain until the carrier's future is stabilized. And these are uncharted waters. I'm not aware of any union that emerged from a bankruptcy without a contract and immediately entered into Section 6 negotiations. Given the National Mediation Board's tendency, there is little possibility of a release during this period of uncertainty. Without release, there is no end game. There's no opportunity to threaten a strike or to present evidence on the merits of the union's case before an impartial board, even under the best of circumstances, when the National Mediation Board deals with a financially healthy carrier. The time between the start of mediation and release, appointment of a PEB, and final recommendations from the board is measured in years, not months. I have taken the time to review the last dozen presidential emergency boards. The time between filing for mediation and the submission of the PEB report ranged from 11 to 40 months, with an average of 20 months. This excludes the infamous 93-month delay by PEB 234 involving Amtrak that most of you have heard about. But even under the best of circumstances, we would not get to a Section 6 conclusion within 2 years. In the meantime, the imposed terms, without wage increases or outsourcing limits, would obtain. And the TWU would be confronting potential suitors, friendly or hostile, without a contract in place. There's no doubt that if American is in play as a merger partner after bankruptcy, the circumstances that the NMB would release the parties during this period are slim, and the Section 6 process will continue without end in sight. It is often suggested that the union can create bargaining leverage during the negotiations because the company and all other stakeholders will be concerned about the impact on operations due to labor unrest or low employee morale. I would not overstate the creditors or the equity investors' fear of labor unrest. What is important to them is reduced labor costs. It is true that the consensual terms are preferred, but imposed terms work just as well. Remember the Northwest Airlines experience. A successful restructuring and exit occurred after the mechanics union struck and the company imposed brutal terms. The total elimination of any scope and a 26% immediate cut in pay. 90% of the M&R jobs were eliminated, and the creditors could not have cared less about the morale for the 700 or 800 mechanics that were left. The value of turning down the tentative agreement and returning to negotiations rests on the assumption that American survives bankruptcy without challenge to its exclusivity within the bankruptcy period, and that it emerges as a stable and standalone entity. Most likely is the outcome that a successful restructuring of costs occur, but a failure to execute the revenue side of the plan results in a merger with an established airline along the Northwest Airlines, Delta, and United Continental models. TWU members are better off facing negotiations in a merger consolidation environment with a contract in hand, particularly one which locks down wage increases and health and welfare contributions and places limits on outsourcing. TWU members would be greatly disadvantaged with respect to seniority and employment rights. I've been talking about the first alternative, that is voting down the tentative agreement. Now let's talk about the other. I understand that the decision you're making involves a choice between two horrible alternatives, but which outcome is the most favorable? The TWU leadership has improved the terms of the previously rejected last best offer significantly. The concession target is lowered under the tentative agreement for M&R by 26%. That's $54 million per year. The replacement pension plan is enhanced to include gross pay instead of straight time only. Including overtime for the M&R group increases the pension levels by more than 10% over the last best offer. Health insurance is also improved. Provisions for active employees are improved as contributions were capped at 21% of the total required contribution. The general wage increases are also better. They're 16% over the term under the TA compared to 7.7% under the last best offer. The midterm adjustment will guarantee that the all-in wage rates will be equal to the average of the big four legacy airlines. 791 PMMs and OSMs who would otherwise be facing a pay cut of $10 per hour will confront a cut half as bad under the tentative agreement. We should all understand that without an agreement, the company will not implement the terms of the last best offer or the tentative agreement. It is most likely to be the March 22nd position or worse, including the outsourcing of an additional 2,000 jobs. The TA eliminates the risk of inevitable Railway Labor Act delay in Section 6 bargaining. And with a successor clause in hand, it places the TWU and its members in the best position in confronting the uncertainty of a merger and/or hostile takeover. Unfortunately, this is a very pragmatic process. There's little room for the union leadership to rest on principle and virtue when over 5,000 families or nearly 45% of the entire M&R group, are confronting the loss of their livelihood, the ultimate catastrophic event in the workplace. It has been said that individuals like me are on the outside, and it's easy for us to voice an opinion when, of course, I don't have to work under the terms offered under the tentative agreement. I respect this point of view. But it is equally true that there are those very senior members who advocate a no vote, and yet their jobs are not in jeopardy under almost any scenario. The good union and the good unionist tries to protect all members equally, understanding that not all members share the same exact individual interest.